Good afternoon and good morning to our West Coast listeners. My name is Juan Thomas, honored to serve as chair of the ABA Civil Rights and Social Justice section. Welcome to our last chair chat for the 2022 calendar year. We've had a great season so far this year, and I'm honored to welcome for our last chair chat for this year, Professor Susan Landau. Dr. Landau is the Bridge Professor in Cybersecurity and Policy at the Fletcher School and the School of Engineering in the Department of Computer Science at Tufts University. Welcome, glad to have you.
Thanks very much for having me. I'm delighted to be here.
Did I get your title right?
Yes, really impressive.
The long, impressive title, and we want to make sure we honor you by getting that right. We're here today to talk about encryptions. Could you first tell our listening audience what exactly is encryption?
Encryption is a way of scrambling communications or stored data so that somebody who doesn't have the authority to look at it, or when they see it, it just looks like a mess.
Right.
So encryption has existed for thousands of years. We know it, elementary school kids know the Caesar cipher, where you shift the alphabet a certain number of letters and you encrypt by just moving the message a few letters over. That one's easy to break, but these days, of course, we have much more sophisticated forms of encryption.
Right. And so in general, why is it important that we protect these issues in the context of human rights here in our country?
Well, encryption is actually important for a lot more than human rights and protecting journalists and so on. We rely on encryption for everything from when you connect to a web page to keep your communications secret, whether it's you're sharing your credit card or whether you're looking at a web page and you're inquiring about when the next meeting of Alcoholics Anonymous is, or finding out the data about your HIV test, or whether or not your doctor's office may have the results of your pregnancy test and what that result is. So we need encryption for all sorts of communications we do, but also for the data that is stored. And increasingly, companies are encrypting communications, what they say, end to end, so that anybody in the middle of the communication, even if they pick it up, they can't understand anything that's in it.
So encryption is important in the context of not only safety, but also security. What is the impact of breaches and corporate surveillance in these discussions? How does this really impact?
Sure. So there are two different ways that encryption can be used. Encryption can be used, as I mentioned a moment ago, in terms of communications. And when you communicate over the internet, your communications are generally less secure than they were over the old telephone wires back in the days when we had a landline that connected to a telephone central office. And that's why encryption is so important in those communications. Encryption is important for data stored, whether it is at the Veterans Affairs, or it's at the IRS, or it's at Visa, which knows what you've spent your money on, or at PayPal. It's important when it's at a company that may have private data like 23andMe, which stores genetic information. And so what you want in all those cases is that the data be encrypted. It's very hard to keep systems, large computer systems, completely secure. And so one aspect of keeping your data secure is making sure it's stored in the databases in an encrypted fashion. So even if it is removed, the thief can't actually get at it.
Well, that brings up, the competing interests that often come into play around this issue. A government's need to collect evidence in a criminal case, for example, versus one's privacy rights in the context of their digital data, for example. What are the implications to human rights, and how do you balance that when there's
Sure.
these competing
So
interests?
one of the interesting shifts over the last 20 or 30 years of the debate on encryption policy is that for a long time, it used to be defined as security versus privacy. But I would argue that it is not security versus privacy. It's really security versus security. And I participated in a Carnegie Endowment for International Peace study a few years ago, in which we had the former deputy director of the NSA, the former general counsel of the FBI, people who had been in senior positions in the law enforcement and national security sides of the government. And we all came to a decision in which we said, you know, the encryption debate is really a debate about security versus security. There's national security, there's business security, there's
Right.
public safety. Protecting your data is a way of keeping you secure. So when data is encrypted or a communication is encrypted, yes, it's harder for law enforcement to do their investigation if they can't find the keys and decrypt the data. But it's also the case that encryption plays a huge role in keeping us all safe. So I would say that it's very much a security versus security debate rather than a security versus privacy. Or even more specifically, it's a security versus the efficacy of law enforcement investigations.
Right, right. Could you give us an update on the Earn It Act bill that's currently in Congress?
Sure,
and talk about what that bill is.
This is a bill that keeps coming up. It's a bill that is intended to protect and enable investigations in various sorts, including investigations into child sexual abuse material. Earlier this year, or maybe last year, there'd been an amendment put in that protected companies when they provided strong encryption so that they weren't subject to liability. That amendment is out in the current version of the bill, which means that a company that provided end-to-end encryption would be liable, potentially liable, if law enforcement couldn't easily access the data. That's exactly the wrong way to go. That is something that makes us less secure. Even, I guess, about 7 or 8 years ago already, the former director of Homeland Security, the former director of NSA, a former senior member of the Department of Defense, penned an op-ed in the Washington Post saying end-to-end encryption is really important for our safety and security. And as I said, our Carnegie study said the same thing. We have many people from senior government security positions who say end-to-end encryption, which is the kind of encryption that only the sender and receiver can decrypt the message. End-to-end encryption is really important. So the Earn It Act is a step backwards, and it's a way of trying to satisfy people about investigations into a very emotionally laden topic, child sexual abuse and exploitation, but it's the wrong way to go about it.
And what do you suggest is the right way to go about it?
Well, in fact, child sexual abuse and exploitation is 4 different kinds of problems. It includes CSAM, child sexual abuse material. It includes perceived data that the child herself or himself may actually provide to somebody else. So in fact, children are increasingly creating pictures of nude photos of themselves. This is really hard for someone your age or my age to believe that a child would do this, but in fact, they are doing this and sharing that. And of course, they don't always share. They share it sometimes with people who might then use it in other ways. There are other ways that that child sexual abuse material happens, including online abuse of children, videos online while the child is being abused at the time. The point about these different kinds of child sexual abuse and exploitation is that there are different ways to prevent it and different ways to investigate it. And when you lump it all under CSAM, when you lump it under one big category, you lose the kind of careful thinking about how to solve a problem, which of course law and law enforcement knows all about, that you need to say, what are the different issues and what are the different ways that we handle them?
Right. One thing I wanted to share with you, Dr. Landau, is that the theme of this year for our section is economic justice. And we're focusing on elevating the economic justice question in the context of larger and broader civil rights and social justice issues. As we all know, this past summer, the Supreme Court issues its Dobbs decision, which overturned Roe v. Wade. In light of that decision, and when discussing access to protections of personal information and personal communications in particular, is there not an economic disparity as to who has even access to technologies like encryptions and other data protection mechanisms?
So there is and there isn't. An app like WhatsApp is available to anybody who has a smartphone, which is in fact a large percentage of the population, although of course there is some economic disparity there. But it's also the case that in general, the iPhone has easier to use privacy protections than Android phones. And easy to use is something really important because I know that when I was using an Android phone, maybe 10 years ago, 8 years ago, I thought I had protected against a certain kind of tracking of me. And it turned out, no, there was yet another place on the phone that I had to do it. And here I am, a technologist. So usability is really important in privacy protections. And then there, Apple wins hands down. And of course, an Apple phone is much more expensive than an Android phone.
Right.
The other thing is that to the extent that free apps are not really free, you are the data, you are the price that you're paying, that is the data about you. So people who choose to use a free app instead of an app that you might pay for that provides more privacy, but you have to check, does the app really provide more privacy? So there is that disparity as well.
Is there a way to make?
I hope you'll ask me more about Dobbs because there's a lot more to say about privacy and all of that. So keying you up for that.
No, please continue. So in light of the Dobbs decision, what other impact do you see that's going to come down the pike regarding encryption?
Right. Well, it's encryption and it's privacy. So we all know that when we type in search terms like pregnancy, abortion into a search engine, that data is being collected. We know when we type in an address of Planned Parenthood or an abortion provider, that address is being provided to the mapping application.
Right.
Most of us don't know that in addition to the terms we put in deliberately, there's a lot more that's collected by the applications. So for example, in order to use my phone, in order for things to display properly on my phone, there's an accelerometer on my phone that knows whether I'm turning the phone sideways or straight up. There's a magnetometer that allows the mapping application to work. There's a gyroscope. There's a battery sensor that says how much battery is left. Some of that data is used to make the phone function more effectively. I know when my battery is down to 20% and know to plug it in. But some of that data is also collected off the phone. And that data, even if you have location turned off, if it's the case that the GPS location turned off, but if it's the case that an app knows where you started and collects accelerometer, magnetometer, and gyroscope information, the app or data brokers that collect the information from lots of apps can actually determine where you've been, whether it's been to an abortion provider or not. GPS only knows which building you went to, but the data that I've just described can say which floor of that building, which office of that building.
Wow.
Wi-Fi information can say which room you're in. So when you connect to a Wi-Fi router, when you're doing so, it often collects or learns what other networks you've been on in the past. And it can learn, oh, you've been on the network in this office, this doctor's office, this provider's office. And that's information that most users wouldn't know about doing. So there's a lot more to worry about than just GPS location. And it's pretty hard. It's essentially impossible for the average user to protect themselves against that.
And that leads me to just wonder out loud, are there pending legislation in response to these privacy issues that
So
you
there
can
is
tell us
pending
about?
legislation on the Hill, and it's supported by both Democrats and Republicans, which is a great thing. Whether it'll make it out this year, what day are we on? We're on the 19th of December. How many more days do we have? Highly unlikely, which means it will have to be reintroduced next year. As I said, it's got bipartisan support. It doesn't protect as much as I'd like, excuse me, but it is certainly a positive step. Europe has been more proactive about protecting privacy. Sometimes that comes at the cost of innovation. Sometimes it comes at the cost of making it harder for American companies to compete in Europe. But on the other hand, it is much more protective about privacy.
So do you believe there are lessons we could learn from our European neighbors on this issue?
Yeah, I mean, Europe, one has to go into the weeds. I mean, there's lessons to learn and lessons not to learn. Getting notices that say, is it okay that you have this cookie, and so on, and you just learn to hit yes, 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 yes. That's not useful. But the kinds of data protections that they are thinking about, including versions of what we call purpose limitation, that data collected for one purpose should not be used for another, and more active efforts on their part is certainly important for us. But it requires legislation, and it requires actually more power to the Federal Trade Commission than has existed up till now.
I see. Well, that leads me to ask you about what role can lawyers play to facilitate this conversation and be more engaged, or to ensure that people's civil rights and civil liberties are protected in a way that would be acceptable to the broader society.
You really gave me one to bat in here. Thank you. So, it's not for nothing that my title is Bridge Professor of Cybersecurity and Policy. And one of the things that I work on and that I spend a lot of time teaching about is how tech interacts with policy and how policy interacts with tech. Some co-authors and I did a paper a few years ago looking at what we call evidentiary software that actually provides the evidence. So when you do, for example, a genetic test, it's software that tests what that looks at your gene. Now, that evidentiary software is often not available to the defense to look at. And so the defense, because it's under a non-disclosure agreement with the police department and so on. Right. Understanding problems that can happen in evidentiary software, understanding that large programs have errors, and figuring out a way to argue for Sixth Amendment protections is one aspect. Another aspect is I worked again with many of the same co-authors on looking at internet protocol metadata as opposed to telephone metadata. So telephone metadata is fairly simple. It's who called whom, when, for how long. But IP metadata, internet protocol metadata, is richer. And for example, when you do a voice over IP encrypted call, which is all voice over, or virtually all voice over IP calls are encrypted. When you do such a call, the packet length, which is something that's in the header and therefore not considered content, can reveal the language you're speaking and even sometimes the words you're saying. Lawyers should know these things in order to be able to better contest issues and protect their clients. So understanding how the technology works is increasingly important for lawyers, and also, of course, for the courts.
I would imagine there's going to be an increasing need, and probably already is. I guess I'm dating myself. I've been out of law school now for 27 years, about 27 years. But we need courses in technology and the law.
There are places that are doing that. Georgetown, for example, has that. University of Texas is looking more at national security and cyber within the law school and so on. But there are places that are increasingly adding that. Understanding how systems work and the potential problems within systems, and therefore what can go wrong and make somebody look as if they're guilty of something when in fact the technology is not actually accurate, or
Right.
when the technology reveals more than the law allows, is a really important thing. And so, yes, I
Right.
would like to see lawyers getting much more technical training, and I'm seeing it in some places already.
Good.
And I'm
Good.
seeing it in the fact that we see law journals that are journals of law and technology.
Right. I've seen those and read articles in those. Are there particular, speaking of those journals, are there specific resources you'd recommend lawyers go to become more educated around these issues?
So it depends what issues and it's a
Those are
complicated
broad.
answer,
Right.
because are you looking at criminal law? Are you looking at wiretap law? What aspect of it are you looking at? I like to go to the Privacy Legal Scholars Conference, which is an academic conference where it's mostly lawyers and a few of us techies. And some of the stuff is purely about privacy and it's philosophical, but some of it is about how does the law and tech interact. There's a recent meeting that started on national security in the law, but I would start, I think, if I were a lawyer, both by looking at what schools offer some one-day courses. On occasion. I've spoken at things at Berkeley, I've spoken at things at Fordham, and those have been excellent. And also, of course, all these Jolt journals at various institutions.
Right, right. Well, I really want to thank you for your time today. Thank you for the education and the knowledge you bring to this subject. We, in our section, we do have a privacy and security committee that I hope we can call on you in the future as a resource.
I'd be delighted.
We'd love to have you help us think through some of these issues, particularly from policy perspective. And if we need to adopt ABA resolutions to advance a policy, we will hopefully be able to do that working with you and other experts in this field. So thank you again for being with us today.
And thank you very much for having me. I really appreciate it.
Right. All, thank you for listening to our final podcast Chair Chat for 2022. Hope you have a wonderful holiday season and Happy New Year. And we'll be back in 2023 to continue our discussion around economic justice issues and the broader civil rights and social justice issues that we face and work with in the context of our section. Thank you all.